For those of you that don't know me, my name is Richard Santy. I'm one of the partners in the employment team at Mills Reeve in the UK, and I'm delighted to be joined this morning by Christine Pellissier from Fidal in France, Christoph Kleinman from Graf von Westphalen in Germany, and Peter Mantel from Van Bentham and Keulen in Holland. You'll hear some really interesting stuff from these guys this morning. The focus, as we say, is remote working internationally, and we've been looking at what the return to work looks like in this country, and we had the session last week on that from Kate and Mel. And what we're looking at in this is what the remote working and the future of work is going to look like in some of our best friend countries. And so, we were talking before we came onto this session just about how people are working currently in different locations, and we talked about the UK's government roadmap and the fact that I think one of the stats was that so many million people had returned back to the office in the UK on Monday, taking the view that, well, the pubs and the restaurants opened on Monday, so why shouldn't the offices be open? But also a lot of businesses are still sticking with the government guidance, which seems from chatting to the guys to be similar in other countries to be, well, you should still be working from home if you can. And so we're just going to look this morning at some of the challenges of working remotely, and also some of the benefits of working remotely and how that will work in the different jurisdictions. So the plan for this morning is there will be a recording available should you want to listen back to it afterwards, and we'll send that on to you. We're pretty tight on time this morning, and we've got quite a lot to cover. So what we've suggested is that you put any questions into the Q&A box, and then if we've got time at the end of the session, I'll pick those questions up and ask the guys as many of them as we've got the chance to do. But if not, then we'll make sure that we pick those up with you afterwards, and my colleagues will be in touch with you to answer those questions by way of a follow-up email. So we'll make sure we get all of your questions answered one way or another. But as I say, if we've got time, we'll do that at the end. Peter was telling us that yesterday he was speaking at a webinar, and one of his co-presenters fainted and fell off their chair live on webcam. So we hope we don't have any issues like that this morning. I'm sure it will run a bit smoother for you, Peter, this morning, we hope. But no, all that remains to say thank you very much to Peter, Christoph and Christine for agreeing to speak at the session this morning. And I think we're going to start with Christine and France. So without further ado, I'll hand over to Christine.
Okay. So good morning to everyone, and thanks to Mills Reeve to give me the opportunity to describe you how remote working works in France. If we go to the first slide, so first good news is that the remote working that you have been implemented spontaneously and without any legal framework during few months now is perfectly compliant with French labor law, because there is an article in the labor code which we probably never used before, which is providing that in case of a pandemic situation, the employer is allowed to implement a remote working without any specific formalism. But now the issue at stake is how to move it to a more permanent organization for the future. And that's what we're going to describe now. If we go to the next slide, we will see the questions that we have to answer. First, who can be eligible under French law to the remote working? And the answer is quite simple. Everyone is potentially eligible to this organization. To say it otherwise, there is no specific criterion or condition imposed by labor law to be eligible to a remote working. So it's up to the company to define the perimeter. But what it's important to notice is that it's a voluntary system, meaning that an employee has a right to apply for a remote working system. And in case the employer says no, he has to provide some objective reasons why he is refusing the remote working organization. So generally the reasons will be business oriented. Uh, this principle of voluntary applies also in the other side. If the employer wishes to apply the remote working organization, an employee has a right to refuse it, except obviously if it was written as an employment contract from the beginning. But otherwise, he has a right to refuse it, and it will not be considered as a gross misconduct. Second question to be asked is how implementing the remote working. In the French law, there are three possibilities. The first one is the collective agreement, meaning an agreement negotiated between the company and the unions. So it's a way dedicated to bigger company having unions, so employing having at least 50 employees. If the negotiation fails, or for smaller companies, there is a possibility to implement it via a charter. So a written document issued by the employer defining the remote working organization. And finally, the last option for small companies, generally it's the agreement. In fact, the French law says by any means, which means that it's not necessary to sign an addendum to the employment contract, and that the remote working organization can be just done by an email defining the terms and conditions of the remote working. Third question to be asked is when. You can implement a remote working organization whenever you want. So in the future, in the near future, or immediately, there is again no time period. So as you can see, French law is quite flexible on this topic, on the remote working organization. But my recommendation would be anyway to draft at least a charter. So you will say, why? Why drafting anything? So that's why what we're going to see now is that there are some topics, there are some important things that needs to be defined. If we go to the next slide now, I want to comment uh, those topics. First, in a charter dedicating to the remote working activity, generally there is a definition of the perimeter of eligible employees. What means a perimeter? What are the job positions available for this organization? Will you include the employees who are on a trial period? Will you include employees who have a very low level of seniority? Those questions must be addressed when starting to work on defining a remote working. Second are the conditions for switching to this organization. Generally, in a charter, you need to define the business conditions. What are the conditions for the employees in terms of autonomy, in terms of experience required? But there are also some material conditions. It's perfectly possible in the French law to impose to an employee to justify an insurance allowing his professional activity from home. It's also possible to impose to the employee to justify that he has a good connection to make the remote working possible. Apart from these conditions to switch in the remote working, there is also another condition another point which needs to be addressed in the charter. It's the place of the remote activity. Will you authorize doing some remote activity from a co-working space, from the second house of the employee? Those are questions that need to be also addressed. Conditions under which the remote activity can stop. What are those conditions? If the employee lacks of autonomy, obviously, probably he will no longer be eligible to the remote activity. But whatever the case where he will access to a new managerial position, will you also stop the remote activity? This is also a point important to address. How to formalize employees? Okay, as I said, an addendum is not necessary. And another key point is the costs. Under French law, generally, an employer has the obligation to provide to the employee all necessary means for his activity. But in the framework of the remote working, there is no obligation to pay for the employee dedicating a space in his personal home to the remote activity. There is no obligation to pay for the electricity cost, for the subscription fees. No, there is no firm obligation to pay those specific costs. But again, this must be addressed. And finally, the last, I would say, important topic is dealing, and I think it's probably the same in other EU countries, about health at work. How first you will control the working time. When an employee is in a remote situation, his working time remains the same, but he will be out of the premises. So how will you make sure that the working time system is correctly applied and that the employee has his mandatory rest period of 11 hours each day be preserved? Because there is a right to disconnection recognized by French law. And dealing also with the health at work, there is the regulation on the workload, how you will monitor the burden of work so that it's not in excess. So as you can see, there are many topics. It's not only defining the days which will be worked as a remote system, it's also many topics. That's why my recommendation is to draft at least a charter. But what happens if you don't do anything, finally? And we move to the last slide. I have tried to list the types of risks that can apply. If you have not objectively defined the people who will be eligible to the remote, and an employee is asking to work from home, and you say no, you may open potentially a discrimination issue because you will not be able to justify the reasons of your refusal. That's why it's important to define the eligible employees. If you have not decided about the place of the remote and an employee is remoting in a co-working space, potentially you have a risk in terms of security of your equipment, in terms of confidentiality. So that's another reason for why it's important to define the place of the remote activity. Also, if the employee is free to remote wherever he wants, he can go out of France, and potentially this has an impact to the social security system that will be applicable. Protection of health, as I said, if you have not defined how you will monitor the working time, how you will make sure that people have rest, you can have potentially an issue regarding the protection of health. That's why generally there are some slides, time slots of availability that are defined, but the protection of health is a big obligation in French law to be followed. And finally, if I could say, because I see that the time is passing, if you have not defined things precisely, you can have a debate in case of an occupational accident. So as I said, to end, there is an opportunity to implement a remote activity because it's quite flexible in France. It's surprising, but it is. But you have a real interest to define things in writing to avoid any risks that can arise if things are vague and not defined in writing. And I have finished for the French law. Maybe we will move in the north, I think.
Yes, to Christophe, I think. Yeah. Thank you, Christine.
Yeah, thank you very much, Christine. Christoph from Frankfurt, which is not in the north of Paris, but might be something.
Oh yes, indeed. Sorry.
Yeah, not a problem. So when it comes to Germany, I have to make very clear that we have a lot of questions and only a few answers. Many questions are open when we're talking about remote working. Just the next slide, please, Lucy. And I'm starting with a few definitions because in Germany, we have to distinguish between what we call home office. We always tend to use English words in the wrong way, as we're saying handy for a mobile cell phone or saying home office for working from home. And we distinguish between home office teleworking and mobile work. We'll use it later on, and then I'll come to some legal duties and challenges and a few lessons about the questions we have when it comes to a return to work from the premises, the offices. Next slide, please. And again, next slide. So teleworking, what we usually are using is home working or home office. That means that the employee is obliged to work at home all the time, not any other working place, but at home. And that has a legal impact with regard to costs and other things. I'll explain that later on in more detail. Very often we have now a model, we say a kind of a hybrid model, working 2 days in the office, 3 days from home or from any other place you like. That's what we call alternating telework. And mobile work means that the employee has the freedom to choose any place to perform his duties. It can be in Paris, or he can be in Frankfurt, or sitting in a pub in London, where you just opened your
yes. Yeah.
As mentioned before, home office means working from home. Next slide, please. Again, next slide. So in general, we have not any legal entitlement for our employees to work from home. There's a clear guidance from the government asking all employees to stay at home, but it's not a legal entitlement. And if you ask your employees to come to the office, there is no consequences for employers if they don't follow the guidance of the government right now. If you agree on an agreement in which can be done in the labor contract by an addendum, very often in a collective labor agreement, German expression would be Tarifvertrag, or in the works constitution law, which means that you deal with your works council. Many German entities have works councils, and it's a special kind of a CLA. In other words, you have to distinguish very precisely whether you're talking about telework, working from home always, or a few days a week, or if you're saying mobile working, which means it's the choice of the employee where he performs his duties. If you define he has to work at home, you have all the cost burden on the side of the employer. You have to provide him with a appropriate desk, screen, chair, whatever you need to perform your duties. You have to run a risk analysis at the workplace, whether it's in line with health protection and safety issues, which is in fact a nightmare. You can't do that properly. That's why we always advise not to agree on a home office solution, but on mobile working, where still there is no obligation to provide the employee with equipment with regard to IT surroundings or desks or whatever. Next slide, please. If you allow people to work from a remote place, you always have an issue with GDPR, or the German abbreviation is DSGVO, Datenschutzgrundverordnung, which is not easy. The general advice is not to use your private devices and not to allow any private use of the company's mobile phones or laptops or whatever. If you do not stick to that rule, you might get in difficulties with data protection issues. And as Christine mentioned earlier, a huge problem is the working time regulations. In Germany, it's a threshold of 8 hours per day, and we have rules like there has to be a break of 11 hours between 2 working days and things like that. And if you're staying at home and the kids you got the kids finally into bed, you're starting again, checking your emails, you would have a breach of the working time regulations under German law. And it's pretty much unclear. There was a ruling of the European Court 2 years ago, whether there is an obligation for the employers to really supervise the working times, even if the people are working from remote places. So that's really an issue. If you really trying to make sure that the working time regulations aren't a problem, it would be wise to supervise really the working time through a technical help or something like that. Yeah. Next slide, please. So, and as in France, the recommendations are to have a precise agreement where you stipulate the kind of remote working, whether it's mobile working or working from home. You can do that in a works agreement, as mentioned before, with the Works Council, if you have one. You should have a privacy police with regard to data protection things. And if you have a Works Council, he always has a right of co-determination. And that means if you don't get the consent of the Works Council, you have to go to court and ask the court to replace the lacking consent of the Works Council. In practice, it's not a great problem because most Works Council are tending to allow their employees to work from remote places. So it's just a question of dealing with the Works Council. Next slide, please. So in Germany, the pubs are still closed. That's why we have chosen the picture you've seen, very short. Until June, end of June 21, we still have a few rules on COVID. We have the obligation to offer work from home, but if you don't do that as an employer, it doesn't matter. In fact, no one will check whether you have offered that or where your employees are working in practice. There are some initiatives by the Federal Ministry of Labor and Social Affairs to implement an entitlement for a hybrid model. I'm saying, for example, 24 working days per calendar year, you might have an entitlement as of next year to work from home or any other mobile place. What we see in practice as a problem is, for example, us as a law firm with about 400 employees, I'd say 70–80% of our staff are working from home or from any other place. And just to keep the, how shall I put it, the team spirit together, the culture of the firm is really a problem if you're just talking like we are right now doing in Zoom or Teams or whatever kind of video formats. And I think we have to avoid that we just say, well, everything is a cost issue, and we could reduce our real estate costs by implementing shared desk models and things like that, without having in mind that we have to keep that culture of co-working. Mm-hmm. So that needs a few thoughts for the future. Mm-hmm. And I think that was the last slide, but I'm not quite sure. Yeah, it was the last slide. Thank you very much.
Yeah. Thank you, Christoph. Yeah, I think that was one of the things we talked about, and I'm sure this will be the same for a lot of you guys in the audience. Is yes, it's very. We talked about the difference when the government says work from home if you can, we were talking before we came on the session about, well, what does that mean? Does that mean if you can from an IT perspective, or does that mean you can if you can effectively? And that's been a real challenge for a lot of our clients, a lot of organisations. People saying, well, clearly people can work from home from an IT perspective because we've all been forced to for a while, and so everybody's now set up working from home. But I think Christoph makes a really good point that yes, of course there are going to be cost savings in real estate costs and travel costs by people working from home and doing these Teams meetings, Zoom meetings. But is it, in reality, I think only time will tell actually what impact and what effect and benefits that we lose from doing everything remotely, when actually there is a massive benefit for people being in the office, talking to each other and maintaining the culture, as Christoph said. So it will be a really interesting balance, and that's certainly one of the big challenges we're talking about as a law firm, and I imagine a lot of organisations have got. But conscious of time, so over to Peter to hear about the Netherlands.
Yes, good morning. This is Peter Mantel from VBK law firm in Utrecht, Netherlands. Great many thanks to Mills Reeve for making this possible and inviting us to this meeting. Current status in the Netherlands. Actually, we had a government advice in place to work from home. Since more than a year now. Essentially, this has not yet changed. You do see employees coming to the office more and more, taking more liberties with that advice, but formally no changes yet. Probably as in other countries, the new way of working took some getting used to, but I believe we all discovered that it's not only negatives there, but brings some advantages as well. There's no commute, better possibilities to combine private life with work. And some research has been done as well. A Dutch university found that 1 in 4 employees wants to keep working from home post-COVID. So quite a substantial percentage there. And I believe that the employers that we speak to in our practice, they're not unwilling to facilitate either. Richard mentioned some advantages as well. There might be some cost cuts involved. And it might well be that we end up in the middle of the road somewhere. I think we can all expect that. You want to have this coherence in your team, but might want to use some of the advantages that I mentioned as well. So the next slide, please. So if we see that employees have a keen interest to work from home, question would be, is there any method for them to enforce such a right? And for a number of years in the Netherlands, we've had a law which is called the Flexible Working Act. And it regulates not only the place of work, but also the total contract hours. So, for example, someone working full-time may, on the basis of this act, request to work part-time. He may request a change of his working times. And he may also request a change of his workplace. Now, the first two, for example, the wish to start working part-time, the employer cannot simply deny such a request. So if an employee requests part-time, the employer must have compelling business reasons, and only then may he deny the request. So what we've seen in case law is that this is really difficult for employers to prove such compelling business reasons. So a request to work part-time was more often than not granted. Same goes for working times, changes in working times. However, this criterion of compelling business reasons is not yet in place for the working place. So based upon this act, an employee can submit a request to work from home, but the employer can simply deny the request and does not have to prove the compelling business reasons. Now, this is about to change because there's a new bill that has been submitted, and it might enter into force in a couple of months' time. And it has a rather ominous name of work wherever you want. In effect, if that bill would be adopted, indeed, the employer must prove compelling business reasons to keep an employee from working from home. So there's a lot of criticism about this new bill. It's therefore also unsure if it will make it. Naturally, if an employee is allowed to work from home, it is very important to make sure that all the conditions and criteria are agreed upon. So I won't go too much into the working from home agreement, as both Christine and Christoph have covered that topic in their presentations. So let's go to the next slide. I believe perhaps main concerns for an employer with an employee working from home, probably data protection, and also some control of where does the employee work. It is not uncommon for us in our practice to hear our clients say, well, we allowed an employee to work from home, but now he has gone off to Spain and is working from Spain. Yeah. Do we have to allow this? So in your working from home agreement, you want to limit these kinds of circumstances. You want to protect your data. You will not want to have your employee work in an unprotected environment without any firewalls or whatever. And of course, main concern is health and safety. Well, quite evident that an employer is responsible also for health and safety at the home workplace. Good ergonomics, good lighting, etc. Employer should also provide training and instruction. The main question here is actually, how do we check compliance? And we've struggled a bit. I've seen Dutch employers asking themselves that question, wishing to, for example, have the employee send over photos of their home workplace or even a video. And of course, these easily come into conflict with privacy laws. So what we ended up with is best practice to work with a checklist. So what we normally do is present an employee with a working from home agreement. With that goes a checklist and an instruction, a link to a video where further guidelines are given. And then together with the checklist, the employee signs off that all of the health and safety requirements are met. Also, the employer has an obligation to cover for the costs to make the workplace safe. And that's been a bit of a struggle as well. We see budgets for home workplace all over the place. Some employers provide a budget of thousands of euros. Some of them would only provide like 250 euros. So that's all over the place now. But some new legislation is coming where we might expect, by means of tax legislation, that there will be more unity in what an employee might expect of such a budget. Next slide, please. Yes, another topic. It is a bit linked to my remark about tax, and I wonder if that would be the same in other countries as well. But we have some tax-free allowances for employees, like a travel allowance, and these were paid on a monthly basis, net, before COVID. But then COVID came and nobody traveled anymore. So the question arose whether or not, under those circumstances, the employer was still allowed to pay out these allowances tax-free. And the tax authority had, given a certain period where it was still allowed, but now employers have to stop these payments or face taxation over these allowances. And it must be that similar problems have occurred in other countries, I think. Where we see employers stopping these allowances now, given the taxation problems, that is quite easy to do because it is not an actual employment condition in Dutch terms. So it's a cost compensation. So it's reasonable that if you don't make the costs anymore, that you stop the compensation. But we have a lot of questions where this might be different. For example, mobility policies or lease cars, where, for example, a lease car was given out to the employee when he had to use the lease car for 80% for his work and 20% for private use. And now, of course, that might have been turned around, the opposite. And questions arise whether it's at all possible to then take away the lease car because it's not necessary anymore, or if that's not possible, perhaps because it's an employment condition and the employee was given the right to use it for private travel as well. That's still an open question. Might be difficult. I think we have a good chance to change these kind of employment conditions, but case law has still to develop in that regard. So I believe that's the last slide I wanted to cover. Yes, that's it from the Netherlands, I believe. Over to you, Richard.
Thank you, Peter. Thanks, Christine and Christoph as well for your presentations. They're really, really helpful, and I hope have given everyone.
You're on mute, Richard.
Oh, sorry. No, I don't think so. Can you all hear me okay? Christoph and Christine?
Yeah, I can hear you.
Yeah, no, good. Hopefully everyone else can then as well. Yeah, thank you to everyone. We've got 5 minutes, so we've got some questions in the chat. We won't get time to cover them all, so we will follow up with some of them. And certainly, I saw there's a few questions that are potentially, I guess, more relevant to wider issues both in the UK and abroad. So we'll probably deal with those separately and try and stick to some of the ones that are relevant for the speakers that we've got. One of the things that was asked, and I can tell you the UK's perspective on this, and then it'd be useful if for you guys, if you've got any input from your countries. But one of the questions we've been asked, and have been asked actually separately by a lot of clients, is, and I think a number of you touched on it, is employees. Christine, you said, I think, working from second homes. We've been asked, if employees have got homes in other countries, or if they're from other countries and have been working in the UK and then go back and work from what would be traditionally their home country, do we need to observe the legal regulations of that home country? Now, from the UK's perspective, that would obviously depend on how long. And one of the questions was, if we only allowed them to do it for a short space of time, do we need to observe the legal regulations of the home country? From a UK's perspective, if it was only for a short period of time, then we would say you wouldn't have to sort of go under UK statute and UK law, UK tax law, for example, if you're only working here for a short period of time. Would that be the same in all your other countries? If somebody was only working there for a month, for example, would they have to observe any specific regulations of your countries? Peter, if I go to you first, you're at the top of my screen.
Yeah. Well, I think it depends a bit. We do have a lot of regulations that might be easily set aside if an employee is working under UK law and is only temporary in the Netherlands. However, there are some overriding Dutch statutory arrangements which would have an impact. And that would be the case, for example, with working times. Yes, if you would come to work in the Netherlands, even for a brief period, you would have to take a look at Dutch regulations there, because they will apply.
Right. That's helpful. Christine, in France, is that the same there? You would not be,
Yes, probably. Yes, there are some regulations in France that would be considered as being mandatory. Working time, paid vacation, etc., would be probably mandatory. So if there is a risk that the employee is claiming to be that his employment relationship be governed by French law, if he has moved to France. And there is also another questions regarding payroll taxes, French payroll taxes. My understanding, I don't know if the other countries have the same position, is that within, I would say, EU countries, there is a position now to consider that the social security system will not change. So temporarily, there will be, despite the fact that people will, for example, work in France, if they were not affiliated to the French system, they will not be liable to French payroll taxes, because we are in the COVID situation. So there is a temporary exemption, but we don't know how long it will be maintained, and probably the best would be to request a certificate of coverage anyway to secure the situation. But so I don't know how it's interpreted in the other countries, but for France, I would say there would be no payroll taxes, but an issue potentially with respect to French labor law. Yes.
And Christoph, in Germany?
Yeah, well, the basic rule is, as long as it is not more than 180 days a year, you shouldn't be subject to German taxation and German social contribution law. But when it comes to public labor law, like working time regulations, there is a high risk that German law will apply. And one other point, which is really crucial, is you have to avoid that your employees sitting in a second home in wherever, France or Germany, conclude contracts for your company, because that could cause taxation problems with regard to corporate tax in Germany or France or wherever. Yeah. So that is a very important point.
No, that's really helpful.
PE.
Yeah, that's really helpful. And just quickly, I'm conscious of I promised you all you'd be done by 10:45. One of the other questions, and I guess I'm only dealing with this just because it flows on from that a little bit, is one of the other questions was, what are the barriers to people working remotely across different jurisdictions? And I guess we've covered a lot of that in the answer to the last question. You do have to be mindful of taxation issues if people are working remotely across just different jurisdictions. And I think the other answer to that was dealt with in Peter's presentation, but I guess applies to, again, across the board, is thinking about how you are able to monitor your employees, how you are able to make sure that they're working in a safe environment, that they might have set up a home office in the UK or in another country, but actually when they then travel to their second home or to another country, what is the situation like? What's the setup like there? Are we making sure that we're sticking to the health and safety laws and making sure that you're sticking to your duty of care to your employees? So I think that's hopefully covered off. The answer to the last question has hopefully covered off the one of the questions around the barriers as well. And hopefully we'll see you on that next session. So thank you all and see you soon.